Hello, my name is Mohammed. I am a student. I'm studying for my PhD in simultaneous and consecutive interpreting with a specific reference to court interpreting. The goal of this video that I am recording and publishing on my tube is to seek the assistance of people who would like to help me. In my study, there is just an experiment that I'm making right now, and I would like just to see your feedback if possible. First of all, let me say something. I'm not a lawyer, I'm just a linguist, and for that reason I'm going to make things very simplified. So perhaps lawyers would disagree with me on certain issues, but basically I'm talking about the knowledge that I have, and I am sure about the knowledge that I have in terms of certain elements of the law. And the purpose here is to explain something, and I would like just to see your feedback. This feedback is going to be very important for me. If you are a court interpreter, if you are a student of interpreter, you can help me a lot by giving me your feedback. I'm not going to tell you exactly what to say to me. For example, do you think, do you believe, etc. Was it useful, was it not? I'm not going to say exactly what I need. What I need, in fact, is just to leave it to you, up to you, to tell me exactly what you have in mind after listening to this video. In order to help me, I would like just to ask you, please, to click the link in the comment of this video in the description. There is a link that goes to the recording that I'm talking about, and this recording is about an actual courtroom hearing in the Warren District Court. It's called Case Closed. There is one episode that I would like you to see and listen to attentively. It is in two parts, part 1 and part 2. It's about a case of a dentist in front of the judge, and the defendant is a patient. Step number 1 in this assignment, let's say, or task whatsoever that you are trying to help me with, step number 1 is to go to this Case Closed episode and try to see it from the very beginning till the end. Please just watch it and write down whatever notes that you want to do. It's not that difficult. If you are a native speaker of English, you will not find any problem with it. You will understand it. If you are a non-native speaker of English or a student of translation, then it needs some kind of listening comprehension abilities. Otherwise, I think there will be some problems. Anyways, this is step number 1, is to watch the video. Step number 2 is to see this recording. So if you haven't seen that video, please just leave this recording for a while and go there and watch that video, and then come back to this explanation, and then you can in step 3 send me your feedback. My email is also mentioned in the description of the video. I will now start my explanation about the video, but first of all, there is an introduction that I would like to make about the law. As I said, I am not a lawyer, so please just forgive me if I am not mentioning all details about the law. The devil, as they say, is in the details. When we have a court and we have a judge, then we have a dispute. This is what we usually have. So when people have a dispute about money, they go to court in order to have a person who is neutral, a person who is not biased, who can listen to the people and just pass a judgment about who owes whom. What happens is that the plaintiff comes with their evidence, and this is what the law says, that the burden of proof is on the plaintiff. The plaintiff explains his claims. It's called claims because a claim can be supported, a claim can be refuted. So the plaintiff can say whatever he wants to say, and he has to submit any kind of evidence that he has. The defendant then talks to the judge, and the judge listens to this one, to that one. He weighs the evidence and tries to see which one is supported. So the plaintiff mainly makes lots of claims. Claim number 1, number 2, number 3, number 4, and all of them are claims. What happens is that the judge uses what's called in legal terminology reasoning. Reasoning is trying to see what's logical, it's trying to see what is supported, it's trying to see if there is a contract, if there is evidence, if there is a witness, for example. He tries to see all of them and try to make a kind of logical conclusion. So he exercises reasoning, then logical conclusion, and then after reaching the logical conclusion, he knows exactly what the facts are there that are supported by evidence. And he would say that claim number 1, for example, is a fact according to the evidence that I have seen. Claim number 2 wasn't supported by evidence, so I dismiss it. Claim number 3, I accept it, 4, dismiss it, etc. So he makes a list of the facts that he has established throughout the hearing of the court. And then he looks into the law and applies the law, and he passes a judgment. If for any reason that the judge doesn't find any supportive evidence or strong evidence by the plaintiff, or a strong evidence by the counter claims made by the defendant, if any, then he would simply say, I cannot understand who owes whom, then I dismiss the whole case. And this is what happens in case closed in other episodes that you can see in the district, in the Warren District Court recordings. So this is basically what happens in the court. Now, when the plaintiff talks, legally speaking, what the judge tries to do also, other than affirming the claims or not, he's trying to see if there is any kind of obligation between the plaintiff and defendant. And the issue about obligation is very legal. It's not like the obligation that you can say, I have the obligation of doing something. It's not a matter of duty as much as it's a legal definition. There is a legal definition of obligation. To make things simpler, I would like to say that obligation is like a bond. It's like a bond connecting two things together. And in our context, it is a kind of bond that connects a debtor to a creditor. Now, this is legal terminology. What do I mean by that? In fact, obligation has two elements. The first one is called responsibility and the second one is called debt. Let me just explain that through a very simple example that happens in our everyday life. You go to the grocer's and ask him to buy a melon, a watermelon, and he says it costs $10. You take the $10 and give it to the grocer's. What happens here that the grocer has now the responsibility of giving you the watermelon. Why? Because he has the money. Your money is in his pocket. Your money is in his pocket. So far, this is a debt because you gave him like a loan, like a debt. It could be like a loan, you can say in simple terms. Now, he has either to pay back the money to you and say, sorry, I don't want to give you the melon anymore, take the money, or to give you the melon. This is what's called responsibility. This responsibility and debt, now we have obligation. And this obligation is called in the law a contract. What is a contract? A contract, it is something that you offer something and the other person accepts it. You say, for example, I want to buy from you a house, this house. And the other person says, yes, I accept to sell you this house to you. So there is offer and acceptance. And there is money, which is called consideration. This is a kind of contract. And this is the first type of obligation that happens in our daily life. There is another question which says, and many people ask this question, which is a legitimate question indeed. What happens if there is no written contract? Does it mean that there is no contract at all? In fact, if there is no contract and you go to court, you make it more difficult for the judge to make a ruling. It does mean that there is no contract, even if it's verbal. Still, there is an opportunity of having a contract. What happens though is that the judge would ask, do you have any witness? Do you have any receipt? Do you have any mobile phone picture or image or whatsoever? He tries to see all evidence in order to see whether there is a contract or not, even if it's verbal, even if it's not written. So, not being written does make a contract not a contract. It's not necessarily the case. It could be a contract even if it's not written. So there is another thing that we have about obligation, about the sources of obligation. It's not only contract. There is something called undue enrichment. Let me explain that, what undue enrichment means. For example, if you go to the bank, and let us assume for the sake of argument that you wanted to deposit some $1,000 in your account, and let us assume for the sake of argument that you, by mistake, you deposited that in the wrong account, in an account of a person who you have never met before. You contacted that person and asked him to return the money to you. He would say, no, this is my money. You go to the court. Now here the judge would look at this case as something called undue enrichment. Undue enrichment, for a kind of explanation, it means that getting money from another person without cause. In other words, getting a benefit at the expense of another. Your money gets reduced and his money gets higher, in other words, because of you, because of the money that he gets from you, without any cause, without any legal bond. So you say to the judge, sir, I just deposited the money by mistake to him. Now he would ask the defendant, did you give him any goods, for example? Did you give him any work? Did you have any kind of relationship between him, a labor, whatsoever? He would say no. Did you sell him anything? No, 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 no. Then it's going to be undue enrichment, because you got the money without any legal cause, without anything in return to that person. This is, in simple terms, what's called undue enrichment. Under undue enrichment, I would like to talk about another concept of obligation and about the law. It's called officiousness, or sometimes it's called officious intermeddler. What does that mean? When we talk about officiousnness, we're talking about something called agency by necessity as well. And let us explain that. For example, you're just you wake up in the morning and you want to go to your work, and you find somebody at the doors or the gates of your house, smiling, telling you, could you please give me $10? You would say, why? He said, look at your car, I just cleaned your car, but I haven't asked you to clean my car. This is called officiousness. It is something that somebody did without asking your permission, without asking you to be your agent, for example, in doing that. And here you have the option to pay or not to pay for him. So if you pay, it's up to you. If you don't pay, he cannot and will never be able to go to the judge and say, I cleaned his car and I want my money. Now, agency by necessity under officiousness, what does it mean? You pass by a house, for example, and you find it burnt on fire and the children are screaming, there is no adult there. You bring workers, you bring equipment, and you hire people, and you set off the fire, and you save the lives of those children. This is just an example. Their father comes, and you say, thank God for the safety of your children, and I did this, and this is my invoice, this is my bill. I just want to cover the expenses that I made. And he would say to you, I haven't made you an agent in order to extinguish the fire. Yes, you haven't, but it is a kind of necessity. Then they go to the court. The judge would say, yes, you did not, the house owner did not give any agency to the officious person to extinguish the fire, but there's another person that did so. It is necessity. Necessity told that person, please extinguish the fire, otherwise people will die. In simple terms, therefore, this is called officious intermeddler, and in this specific case, he will get his money paid to him, even if the house owner did not ask him to do so. Another source of obligation has to do with what's called unilateral volition or unilateral will. It is usually called a promise of reward. You go to the mall and there is something in the mall, there is a sign, and this sign says, buy, for example, 3 kinds of chocolate or whatsoever, and you get a refrigerator for free. Let's say this example. You do that and you buy the things that they have asked you to do, and then when you come to take the refrigerators, they would say, no, we don't want to give it to you. Simply, we don't want to give it to you. This is somehow, it is similar to the contract, but not a contract. It is some sort of contract, but this is something that can be called unilateral will. They made the will, and they said, we will give you this refrigerator, and you did something in return for this refrigerator, which is to buy their goods or whatsoever. So they are bound now to pay you, to give you the refrigerator or any kind of reward. It's called promise of reward. And it has other implications in the law. Sometimes it doesn't apply, sometimes it applies. As I said, I'm not going to get into details for 2 reasons. First of all, they are too much complicated. And second, if you ask about a lawyer about that, he would give you all circumstances and all exceptions and all problems. And he would say that it doesn't apply all the time. But I'm just trying to make things easier and simpler in order for us to understand the video that I am going to discuss, which is case closed. Now, there is another source of obligation, it's called tort. Under the tort law, it is that, for example, when somebody throws a stone on the window of a car and he destroys it, under the tort law, he made some harm to you. And this harm or damage it is something that he has to compensate you for. So there is also another source of obligation. It's called the law. If the law, for example, states that a worker cannot work more than 10 hours a day, as in some countries in the world, and if the employer obliges that person to work for more than 10 hours, then he can go to the court and say to the judge, it is the law. The law says that I shouldn't work more than 10 hours, and he is obliging me to work for more than 10 hours, therefore he has to pay for overtime or whatsoever. So these are the sources of obligation. Why am I explaining all of these things? Let's go with details to the case, closed case that I referred you to. It is the dentist came and tells the judge about this story. She says that she was at her desk, it was off working hours, and suddenly the patient, the defendant, came to her. She comes to her and she says she has a bad tooth. They made the diagnosis and they checked on her, and they found that there is abscess on her tooth. And they gave her two options, either to remove the whole tooth for about $70, $100, or to do what's called the root canal and to remove the abscess. So she chose the other one. They said, okay, it costs blah, blah, blah. She said, I have insurance through her deceased husband. They called the insurance company to check on that, and the insurance company says, no, she is not covered by the insurance. She says, no, I am insured, and they were confused. The dentist was confused. She talked to the manager of the place there, and he says, we will take her words in good faith, and maybe there is a problem with the insurance company they want to solve, so let us do the treatment, and then we can solve the money. They treat her tooth, they remove the abscess, they clean the root canal, and they ask her to pay the money. She doesn't pay anything, and she says, go to the insurance company. They go to the insurance company. The insurance company says, no, she is not covered anymore, and she has to pay for the whole procedure. She refuses to pay for the money, and now they are in court. Now here is the issue. Now the judge is asking several questions. First of all, he's asking very simple questions, and he realizes that they don't have a contract. They don't have anything written. The basic thing is that when you go to court, the easiest thing in order to prove your case is to have a contract. There is no contract, obviously, with the dentist and the patient. No payment arrangement, for example. Therefore, the position of the dentist is getting a bit weaker than supposed. So he asked her several questions. I would like to explain them. One of the questions that he is asking her is saying, did you check with the insurance company before or after the procedure? She said they checked before. Now here is the problem. They checked before, and they got the information from the insurance company that she is not covered by the insurance. So they know exactly that she is not covered by the insurance, and still they give her the treatment service. So the position of the dentist is getting a bit weaker. Then the other question by the judge is, now he says to her in fact the dentist during her presentation of the case, he said, look, the patient, look please, we will not leave you without treating your tooth, and this is a problem now. So the judge is asking that. He says, earlier you said to me that you told her we will not let you go out from this clinic without treating you. What does that mean in legal terminology? What does that mean in legal jurisdiction? It means this is a promise. They are making a promise to her. What do we have here? We have here unilateral volition, unilateral will. Remember the promise of reward that I talked about? It is very similar. So, in other words, they are officious people. They just wanted to do something that they are not required to do. And this statement that she has made is, she says, we will not let you go out without making a treatment for your tooth. This is a kind of promise. Now, this is a problem, because if you do something to somebody without getting his consent, that person, logically speaking and legally speaking as well, doesn't have to pay you anything because he hasn't asked for the service. So the judge wanted just to be assured of that, and he just asks another question. And he says to her that when you said to her, we will not let you go without treatment, what if she goes home without treatment? What happens to her? Now, from a health perspective, what happens to her? The dentist says if she goes home without a treatment of the abscess can go to her bloodstream and can kill her. Now, the judge felt very happy by hearing that, by the way, because now we're talking about agency by necessity. In other words, it was very necessary to make this treatment, otherwise she might have died. Now, if the plaintiff proves this, then logically speaking, legally speaking, the defendant has to pay that because it's a case of officiousness and a case of agency by necessity. Now, anyway, she says that when he asked her about whether you can you treat her even if she doesn't have any money, he wanted just to make sure that if it is a unilateral will or not. She says we told her it cost money and she has to pay, and she told us there is insurance. So this is the case that happened in that recording. What I wanted to stress is that every question that the judge was asking, he was trying to see what kind of obligation is there according to the law. If there is a contract, it's going to be different from there is a unilateral will. If there is a unilateral will, he wants to see if there is undue enrichment or not. If there is undue enrichment, in other words, the patient received the service without paying any money for that, then he wants to say whether it is agency by necessity, a necessary action to save lives, and in this case the defendant must pay the money, or in other words, if this is not necessarily to be paid, therefore the defendant is going to be left with the option whether to pay for the service or not. So this is the brief what I want to explain about the video. I would like you now please to ask you, if you want to help me with this study, is to go back now to the case close episode and try to listen to it again, watch it again, and tell me about your reflections after if you hate my words. Remember, I'm talking about simple things that are happening, simple things that are being talked about, simple phrases, simple words, but still they have very important legal consequences. In my study about the teaching of court interpreting, what are your reflections after you heard this presentation? Thank you very much for your help, and I hope that I listened to you, and I'm looking forward to your reflections. Thank you very much.